Thank you very much, Senator Blunt. Mr. Goodman, I want to ask some questions about your thoughts about disclosure being some kind of violation of the First Amendment. If you give $100 to my campaign, I have to disclose your name, address, occupation. But if you give $10 million to my campaign in the form of a super PAC or against me, there's no disclosure. I don't really get that. It seems to me the identity of the donor is relevant information for the public, and I don't understand why it's an invasion of a millionaire's privacy to have their names known, and it's not an invasion of my next door neighbors when I have to disclose their name when they contribute to my campaign. Explain why we have these two parallel systems that just can't be reconciled.
Yes, Senator, the courts over the years have drawn a sharp distinction between the disclosure that is permitted under the First Amendment when someone gives money to a political committee or makes an independent expenditure to fund explicit electoral speech. And the individual who gives your campaign $2,800 per election or $150 or $200 is disclosed publicly, and all of those names are publicly available on the internet. When the millionaire
Why shouldn't that rule apply to
gives
somebody that buys ads that says I'm a scoundrel?
I'm sorry, I spoke over you, Senator. I'm sorry. I missed that.
Why shouldn't that same rule apply to somebody who spends millions of dollars to buy ads on television during a campaign that says I'm a scoundrel or I'm a saint?
The boundaries drawn for that are if the millionaire gives money to a super PAC, then their name is publicly disclosed because a super PAC is a political committee that discloses all of its donors. Now, where the law has drawn the line is the disclosure is permitted constitutionally so long as the speech that it is funding is explicit electoral speech, and in the Bipartisan Campaign Reform Act, that notion or that realm of speech that can require disclosure was expanded to electioneering communications. This bill, however, this bill would require that disclosure if all you want to do is a year and a half before the election, you want to talk about legislation pending and attach a senator's name to it in a favorable or unfavorable light. This bill would expand that public disclosure to people who want to talk principally about public policy and issues under a vague standard called PASO, where anything that would be deemed favorable or unfavorable about you in that context would trigger disclosure of the people who fund that speech. And I believe that the courts would strike that as overbroad.
I don't agree with you that there's full disclosure of people. I don't believe that there's full disclosure of people who are contributing dark money to campaigns through 501c4s and other formats. I don't think that happens. In Maine, if you go to a town meeting, you can't wear a bag over your head. People have a right to know who's expressing their opinions, and that's part of the information that's important to the voters. Madam Chair, before I go any further, I wanted to mention something in the prior panel, and I didn't get to. I think we need to be careful in the bill about requiring paper ballots, which I'm totally supportive of from a security and cybersecurity point of view, but we have to consider people with disabilities, and so that's something that I think we can work on as this bill moves through the committee and into the Senate. But I think we need to be aware of some of the subtleties here involving people with disabilities. Mr. Potter, it's nice to see you. I think you and I were at the last hearing of this Rules Committee on campaign finance some 5, 6, 7, 8 years ago with Justice Stevens. Can you talk to me about the disclosure and the importance of disclosure? And am I correct that I think dark money comes into campaigns through independent expenditures, and we can't find out who they are?
Yes, Senator. It's good to be back in this room with you virtually. on this subject. We still need work on it. Your question points out why, which is you're right. Somebody who gives you money is disclosed, or your opponent money, over $200. As Mr. Goodman says, if they give to a super PAC, the identity of the person or the entity giving to the super PAC is disclosed. But if they give to a C4, which runs the very same ad that your opponent could be running or that the super PAC could be running, then there is no disclosure of the donors paying for that ad. And as I indicated in my opening remarks, what can happen is that the C4 gets the money and then it transfers it to a super PAC, which spends it. So you end up effectively gutting the disclosure provisions even for the super PACs. And that's the key problem we have here, and that's why we've seen this wave of secret money in elections.